Does a mentally competent, terminally ill patient have a right to physician-assisted suicide? To find out, you have to read Myers versus Schneiderman, but it's 43 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I normally cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. But this is a special series. This is part of a series on cases relevant to elder law and estate planning. This is the case of Myers versus Schneiderman. The citation for this case is 2017 New York Slip Opinion 06412, published by the New York Court of Appeals on September 7th of 2017. The issue in this case is whether mentally competent but terminally ill patients have a right to physician-assisted suicide or aid in death or aid in dying in New York State. The law you have to understand to appreciate where this case fits in is that there's two statutes that talk about physician-assisted suicide, arguably. First is Penal Law Section 125.15 sub 3, which is manslaughter in the second degree. Under that penal law section, so it's a crime, it's a C felony for a person is guilty of manslaughter in the second degree when, and sub 3 is, he intentionally causes or aids another person to commit suicide. That's manslaughter 2. And Penal Law Section 120.30 is promoting a suicide attempt. A person is guilty of promoting a suicide attempt when he intentionally causes or aids another person to attempt suicide. That is an E felony. And those, as you can see, don't specify who the actor is. If it doesn't distinguish between different actors, a violent person or a nonviolent person, a physician or a non-physician. And that's the context of this case. So what are the facts of this case? The facts are, there aren't that many facts, but basically there are 3 mentally competent and terminally ill patients in this case that are the plaintiffs, along with some doctors and a not-for-profit that promotes the right to have physician-assisted suicide. The 3 competent but ill patients, one of them is a 62-year-old person with Lou Gehrig's disease, which is a neurodegenerative condition that's irreversible and without a cure. This particular patient was in constant pain and was aware that this would go on for the rest of her life. The second person was 57 years old and had AIDS, which is the acquired immune deficiency syndrome, also without a cure. She had developed laryngeal carcinoma, which is cancer, and had to take more than 24 medications every day, slept 19 hours a day, and the 5 hours or so that she was awake, or he was awake, he basically had to spend that time cleaning his feeding tube and oxygen tubes and taking medications, and required morphine for pain management. And the third individual was in his 80s and had cancer, which was then in remission, had his bladder removed. And each of these individual patients were seeking wanted the ability to have a doctor write them a prescription for a lethal cocktail, a lethal prescription that would allow them to end their suffering if it came to that, and they could kill themselves under a doctor-prescribed dosage of medication. And there were medical providers, the doctors here were medical providers who said that they wanted to be able to prescribe lethal doses of medication to patients, and the fact that these things were criminal under manslaughter 2 and promoting a suicide attempt, as I just discussed, meant that they weren't able to give their full professional opinion that they would. And finally, there was an organization called End of Life Choices, who provide information and counseling on informed choices and end-of-life decision-making. The procedural history is the plaintiffs in this case sought a declaratory judgment. It wasn't the kind of thing where someone was prosecuted for manslaughter 2, a doctor was, and they challenged it at constitutionality. This was sort of they were seeking a legal opinion as to whether this statute, as applied to them, was constitutional. They sought an injunction against prosecution of doctors who prescribed medications like this, and they wanted basically a declaratory judgment that allowed them to do this. The Supreme Court granted the motion to dismiss, saying this is the failure to state a cause of action. There's no claim here. It's not a case or controversy, which is what courts are really there to decide. And the appellate division modified and said that there is no right to physician-assisted suicide. It goes to the Court of Appeals, and here we have a lot of papers. It's 43 pages because there's a per curiam, which means there's a general decision from the bench, and then there's a couple of different concurrences. There are 3 concurrences. Basically, the summary of the main decision, the per curiam, says that there are 2 questions of law here. As to the question of whether they can even review this case, that's the first question. They say there's 2 questions here, and they're both questions of law. The first is whether aid in dying constitutes assisted suicide within the meaning of that penal law. And the second is whether denying mentally competent but terminally ill patients aid in dying violates equal protection. Because they're both questions of law and not questions of fact, the court says we'll take those up anyway, even though there's no case or controversy currently in front of us. As to the question of whether assisted suicide excludes physicians who provide aid in dying, does the crime exclude doctors? It does not. It applies. The crimes apply to anyone, including doctors. It does not limit it to certain people. So assisted suicide statutes apply to doctors who intentionally prescribe a lethal dose of medication. It's also promoting a suicide attempt. And upon completion would be manslaughter in the 2nd degree. But the bigger and interesting questions here are the constitutional questions. The constitutional questions, basically, they have to confront 2 different arguments. First is that this is a violation of equal protection because there are some patients who are on like a ventilator or some kind of device where they can say to their doctors, I want to be off of this life-sustaining device, and they can be removed and then die. But other patients, like these patients who are terminally ill, but are not on a device like that. So they're saying this is not fair. We're being treated, we are both, terminally ill in some ways, but they get to die and I don't get to die. So the question is that a violation of equal protection? And the answer is no, it's not. And the reason that the distinction here, the reason why it's not a violation of equal protection is because everyone can refuse unwanted medical treatment, but nobody can assist in a suicide. So they draw a distinction between active and passive, and they draw a distinction between removing something that's keeping you alive and putting something in that will kill you. The second interesting argument here, the constitutional argument, is due process violation. The argument is that there's a fundamental right to bodily autonomy, and if they want to kill themselves, that's part of their fundamental right to bodily autonomy. But the Court of Appeals says no, it's not fundamental, and because it's not fundamental, it only requires a rational basis review. The question is the statute rationally related to a legitimate governmental interest? And they say yes, and they cite a bunch of different legitimate governmental interests, including guarding against the risk of mistake or abuse, preventing distribution of the prescriptions for lethal dosages of drugs that could kill someone, preserving life and preventing suicide, maintaining the physician's roles as healers, protecting vulnerable people from indifference, and avoiding a slide toward euthanasia. They say that each of these are rational reasons and legitimate governmental interests. So that's the general holding. There are 3 important concurrences, one from Judge Rivera, and she concurs, but she says there's no rational basis to treat them differently. She says if you're going to allow a terminal sedation, this is an interesting point she makes. If you allow terminal sedation, which is IV administration of sedatives and painkillers, coupled with withholding of nutrition and hydration, that's basically killing the person. And if that's allowed, which it is in New York State, there's no rational reason to treat this differently. So she would find that. And with respect to Judge Fahey, he focuses on 2 particular of those legitimate bases. First is opening the door to voluntary and non-voluntary euthanasia, and that it would inevitably expand to include people who are not terminally ill. Importantly, for practitioners, he notes that there are several states that allow physician-assisted suicide, including Oregon, Washington State, Vermont, California, Colorado, and Washington, D.C. The closest one to us in New York State is Vermont. He says certain states allow physician-assisted suicide, but no states allow euthanasia. And the difference being euthanasia is a doctor killing a patient. Physician-assisted suicide is a doctor allowing a patient to kill themselves. And lastly, there's a concurrence. So that's basically the most important concurrences we have here. And so at the end of the day, the important thing to remember is it does not exclude doctors. If a doctor assists someone to kill themselves, that does fall under the penal law sections of manslaughter 2 and promoting a suicide attempt, and it is not unconstitutional. And that's the case of Myers versus Schneiderman. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.